Are we right? So guys, we have let you guys out of the waiting room. If you guys are waiting to get in, we are going to go ahead and ask you guys to mute yourselves at home if you would not mind. So hopefully you guys can hear us at home, and we are going to go ahead and mute everyone. So thank you guys again for being here with us today. I am going to give us a little bit more of a volume behind us with using your bag. That is a impromptu. That should, as long as you can see your screen here. And then at home, you guys can also see this in the back for those of you guys that are here in the office live with us. So I will just very quickly let you guys know why we are here today. We are here because we have a great presenter to you and a good attorney friend of mine, Namit Bammi, and I have worked together for almost a decade. So he's going to be introducing himself and talking a little bit more about what his background is. But he is an amazing real estate attorney. Andy, I know, a longtime top agent. Mary, great agents in our office that have been with us a long time and do a lot of business. They also use him. And so what we are doing is, as you guys know, we have a consumer education series every month. We try to do a different topic in health and wellness, personal finance, charity and community, and then obviously, of course, real estate. And this month, our topic is how to hold title to property. So whether it's your first property or whether you've got dozens of properties, it's time to start looking at what exactly you're going to do with those properties in order to protect them, make sure that you're not in a position to have this asset taken away in terms of if there's an accident or something like that. Estate planning. This is going to be part of a series. Next month, we are going to be talking about green and sustainable housing. We want you guys to kind of expand your mindset in terms of what's possible with green and sustainable housing. Then we're going to kind of come back a little bit to this topic in March. So we already have our March topic as well. And that is going to be actually estate planning. So it is the first time we have ever done an estate planning, wills, trusts, that kind of stuff, that type of class for you guys. We've talked about it for years. We finally have someone truly talented in that space that is going to be talking to us as well. So without further ado, before I introduce our speaker, I do want to thank Emily and Shaheen. They are always wonderful as our hosts at our Skokie office. We have a lot of guests in here today, both consumers and also we have people at home that are watching, but we have people that are consumers that are live in our offices, and Emily and Shaheen always do a wonderful job of making sure the Skokie office looks fantastic. This is Shaheen's building as well. So for those of you guys that are looking to invest more in real estate, look to Exit Strategy Realty because we are investors. We are not only owners of our own properties, but we are investors. 2 out of our 4 office spaces are owned by our agents. That will soon be 3 out of 4, and hopefully eventually 4 out of 4 or 5 out of 5 if everything comes together by the end of the year. So Namit, I want to thank you again for being here. Remind me at the end, for those of you that are live in the classroom, these are always hybrid sessions. So you can Zoom, you can catch the recording later on our YouTube channel. But if you're live today, remind me, we have a bottle of wine in addition to food, and that is a gift from our wonderful speaker today. I'm going to give it away. I will figure out while we are listening to him the best way to raffle this off to you guys. And if you are at home, maybe next month we will see you live in person. Next month, in February, it is going to be at our Cottage Grove office. And then the March session will be at our Joliet office. So we'll be rotating all around our 4 offices. Eventually we'll get to the one but where I live in Lakeview. But we want to start with everybody else first. So again, thank you so much for being here, being patient with me, and let me go ahead and get our screen share going for you, sir.
Perfect. Thank you, Nick.
You're going to want the whole desktop to be sure, or do you just want the PowerPoint?
Just the PowerPoint's all.
Just the PowerPoint?
Yeah,
okay. Perfect. All right, so everyone at home should be able to see this as well. And I'm going to let you take it from here, sir.
Thank you. First of all, I'd like to thank Nick for inviting me out here to go over how you can take title and ownership of real estate. My name is Namit Bammi of Bammi Law Group. I am a real estate attorney here in the Chicago metro area. I've been practicing since 2006, so I've hopefully seen pretty much everything you can see out there as far as it comes to residential real estate transactions. So today's goal is really to educate everyone, and I'm sure a lot of you know a lot of these things, but kind of educate everyone on different ways you can take ownership of your property, ways you can protect yourself better. And then this is going to be very casual, so we will open this up to questions and answers at any point. If someone here in person has a question, just stop me and I'm happy to answer that question or elaborate further. Also on the presentation, and I think I've given almost everyone a card, I'll pass them around. If anyone has questions in the future, you're more than welcome to reach out to me or to Nick, and I'm happy to help you out. So with that said, I think we'll get started if everyone is ready. All right, so once again, today we will be talking about different ways you can take ownership of your real estate. The first and most common, as most people know, and if I'm blocking the screen, I apologize. Let me kind of move this over. I can talk about it.
Could you hold on for
Yeah,
1 second? We do
absolutely.
have a note that some people are not able to join the Zoom, so let me very quickly just momentarily here get us in. If you are waiting at home, we will hopefully be able to get you. It says that everybody should be able to be in at this point. Well, hopefully that is just someone that does not know how to work Zoom. We will find out soon.
Which is a different seminar from today. All right, so we'll get back to this. I'll get out of everyone's way so they can actually see the screen and get rid of the soapbox that came up for some reason. Showing that. All right, well, we'll just deal with this for now. Anyways, so the first and most common way to own real estate would be in your own name. So if your name is John Smith, you're representing a client, John Smith, he's buying a condo, he's buying a single family home, whatever it might be, a multi-unit property. The most common way to purchase real estate is in your own. So you are taking title in your name. There's a couple different ways you can do that. The first is as an individual. So if you're just by yourself, there's no one else you want to be on title or ownership to this property, you take it in your name as John Smith. You are the owner. You are the only owner of this property. The next way is, let's say you are married and you and your wife are buying a house together. You would take title in a form that is only reserved for married parties called tenancy by the entirety. What this means is you both own the house together 100% and separately 100%. What this does for you, if you do not have an estate plan in place, like a will or a trust, and something unfortunate was to happen to your other spouse, all I would need to sell the property in that instance would be a death certificate. It would not go into probate. It would not go into anything else unless you have a will or trust in place that dictates what happens to the property at that time. So this is the best way for a married couple to take title if they're going to live in the property as tenancy by the entirety, because it protects both the husband and the wife if something unfortunate was happened to one or the other. Does that make sense? Wonderful. The next common way to take interest in a property, if you are buying it with more than one person, but you're not married, or you're married and you're not going to live there as your principal residence, which means you actually live in the property, would be joint tenancy. So what this means is the 2 people or the 3 people or the 10 people own the house equally. So there's no percentages assigned. You each own the house equally. So if there's 5 of you, you each own a 1/5 of that house. Okay? Next is tenants in common. This is a way that multiple owners can own title in a property, but rather than owning it equally, like joint tenants, you can set varying ownership percentages. So I can say John Smith has 20%, Susie Smith has 15%, so on and so forth until we add up to 100%. So that's kind of how that works. So in that instance, if you own the property as tenants in common and there was some sort of a dispute or something happened, you would literally have a voting stake based on your percentage of ownership in the property. So those are the most common ways, and actually the only ways you can own property in your own name. And this is probably what most of you have seen if you've ever paid attention to a deed or overheard attorneys talking at a closing or whatever the case might be. This is the most common way. Now, really quick before I move on to the next slide, the risk with the most common way is when you own property in your own name, guess what? If something were to happen, if you got sued on the property, it all comes back to you because you are the owner of the property. So you are 100% liable. And that's why you have homeowners insurance in place to protect you. But when it is in your own name, all the liability falls on the owner in title. Any questions right now before I move on to the next slide about owning a property in your own name, please?
So, okay, so if you own individually, so what are the other ways around that? So you don't have it all in your name and be liable? Is that what you're going to the next?
We're gonna get to that next.
All right, got it. All right.
Yeah, absolutely. Good question. And I'm gonna get to that next. And we can talk about that in more detail. Please, whoever wants to go first.
Go ahead.
So when you have a couple
Yes,
and you buy a property before the couple becomes a spouse.
Mhm.
And it's bought under her name.
Mhm.
And then you get married,
Mhm.
you leave the house, you pay the mortgage. What kind of ownership is there for the person who's not on title?
Okay. So that's a little bit of a loaded question, and there's two parts to that. So the first is you're dating someone, that person owns the property 100%, you get married. What protection do you have? Technically, the only protection you have, there is spousal privileges in most states. And what would happen is if you were married and you're both living in that house, even if your name wasn't in ownership, when you sell the property, she would have to have you sign on the deed waiving your homestead rights. Because at least in Illinois, they don't want one spouse to have another spouse sell something from underneath them without their knowledge. But that is only for principal residences, if you both lived in the property. So you don't necessarily have any rights to the property, but you will know if she is selling the property because you would have to sign off on the deed, waiving your homestead right. Because otherwise you do have rights as a spouse and you could possibly stop the sale. The other thing you can do, and possibly the more favorable thing is, once you get married, presuming your spouse is okay with this, you would do something called a quitclaim deed. And we would draft that up and basically we would change the ownership from Jane Smith to Jane and John Smith, husband and wife, as tenants by the entirety. And then we would record that with the county, and now you would both own the home. That's the safest protection, but you're still protected with homestead rights, but the only protection you have is she could not sell the property without you signing off on the deed. But if you're in ownership, then you have all rights that
So would it go to probate then if the person that on title died?
if the person on title died and they're married and there isn't a will or something in place, well, everything goes to probate eventually, but yes, it would be up to the courts to determine. And then people could come out of the woodwork. If she has kids, she has brothers and sisters, uncles and aunts, they could all come out of the woodwork and say, we have a right to this property too.
Is there a chain like in Illinois? Because I thought I heard once like Wisconsin is slightly different where the chain like of who would have priority in that situation.
There are chains to that, like what they would determine like in probate court as to who you have to go to. It's typically in Illinois, I think it's like the next two. So it's like, if you had children, it's the children first, and then it could go down to their children if they had children. It could possibly go to siblings too, depending how things are set up. But yeah, there is a chain, but the biggest, most important thing is you never want to get to that point. So it's very important that you have a will or trust in place. You know, once you're past the age of 21 or you're married or you have kids or you now have assets, it's very important to get that in place. And I know Nick, the next seminar is going to discuss that. So it's very important to do that. Otherwise, like Andy mentioned, it gets very complicated. And then there's a lot of infighting and it can take a long time for the estate to be distributed. Or you protect yourself with your real estate by making sure it's titled properly. Like you just mentioned, if you got married, get on that title.
Real quick here, years ago, I sold a joint tenant situation.
Yep.
To two people who worked together, they weren't related, and they bought the property and joint tenant. It was a two flat, so there were equal units.
Okay.
For the garden, but they set it up so that they could, one of them could sell their unit. Individual, you know, separate of the other one agreed. Is that how it still is?
So if they were separately pinned, I don't know how the property was set up. Was there,
Two flat,
but you can have a two flat that just has one pin number.
right,
To sell it separately, they each have to be separately pinned, so they're almost condo.
okay.
So if it's condo,
This was years ago,
in-
so.
so if you're buying a multi-unit, number one with like a business partner or whatever, I would always recommend doing it in some sort of entity like an LLC. Because then we have an operating agreement that upfront.
Mhm.
A lot of people don't want to spend the money up front, but it's better to spend the money up front than spend it later on litigation. I always tell clients, and I don't do litigation, I'm a transactional attorney, but we draft things like operating agreements, set up LLCs. And what that would do is upfront, You come up with a document between you and your partner or partners, and up front, you determine what's going to happen.
Right.
So if I die, what happens? Let's say one of us wants to sell and the other one doesn't. Does that other partner get right of first refusal, which means they have the first right to buy you out?
Yeah.
If they don't, you can sell your interest to someone else, but that would all be spelled out in a document that controls, it's kind of like the Bible for your real estate, and it controls what happens. It's better to do that up front if you're going into business together than get in a fight later, because the cost to set this up and for me to draft an operating agreement is minuscule compared to what you're gonna spend in court.
Sure.
Because litigators are not cheap, and litigation is anything but quick. It can take years.
So very good.
And it's very stressful, yes. So that's a great point. And that's what we're gonna get to next on the next slide. But yeah, if you're going into business with someone, I would definitely encourage you not to own a property in any of these ways. Because your protections are very low, and there can be a lot of instances where you can get in a fight with someone. My point is, when you're going into business with someone, everything's great. Everyone's happy, you're excited, but as soon as something goes wrong, that's when the tides turn. And if you're not protected legally, you're gonna be in for a lot of pain. Financially, stressful, just everything. So it's very important to keep that in mind.
One more question.
Please.
In this way, you can claim that you live there for property tax reasons, right?
If you live there, yeah, you mean if you're occupying,
Okay, now,
correct.
when we switch it to a trust, that won't, is that possible too?
Well, that's different. So a homestead exemption is with the county that you're in. So if you are living there as your primary residence, you are always entitled to a homestead exemption.
Okay, good.
So that has nothing to do with your estate. That has to do with the county. That's,
Okay, good.
that's a guarantee. If you live there, you can apply for a
A lot
homestead
of
exemption.
people have a conception, if I put it in a trust, I need that.
No, the trust has nothing to do with that. As long as you are living there, because when you fill out the homestead form for the county, it makes you attest that you are living at the property and you own the property. So that's all that does.
Great.
Yeah, nothing to do with your estate.
I have a question.
Please.
One of my investors, she bought an investment property on her own name.
Okay.
No, on LLC name,
Okay,
that she created a single member LLC in this, which is fine and all that. However, she wanted to do a refi that and do a cash out from it, but no lender would do, I mean, not no lender, but Fannie Mae, Freddie Mac type of lender would not allow to refi in an LLC name. So then you have to quit claim from the
Yeah.
LLC into the personal name.
correct.
And now the property is in the personal name.
Right.
But she asked me what the reason for LLC was so that you know, it's the liability.
Protection, yep, absolutely.
Protected. But when you go back to the individual, now there is no liability protection, so, but can she do again, put the property back into LLC? I don't know.
Yeah, we could do a quitclaim deed back into the LLC. I presume it's still in good standing,
Correct.
as long as the members of the LLC are the same as who's on the mortgage. I presume she's not adding extra people.
No,
Okay, because otherwise she'd have to get consent from her.
correct.
Okay, so yes, we could definitely, so that's a good point. So lenders, and we're gonna talk about that when we get to the next slide. Anytime you purchase real estate, typically a lender will not let you purchase it in the LLC unless the LLC has significant assets, because they need someone's name on that document that they can go after.
Yeah.
So they will likely not approve an LLC to purchase. It's different if you're taking a commercial loan versus residential. A lot of times with commercial loans, they definitely will, but that's a different topic altogether. But for residential, you will have to buy it in your name. And then later on, you could always quit claim it into an LLC.
Correct. I'm also a lender, I mean, a loan officer.
Oh, then you know more than everyone.
So when we have a mortgage note signed that they will not change the title in
Yeah.
any way.
Yeah.
Yeah,
Okay,
yeah,
otherwise they can recall
yeah,
the loan.
Yeah.
I mean, so I checked with another attorney, so around 99.9% it never happened with the law.
right. He or she is.
Yeah, but you know, it's if you have it quit claimed into an LLC back in,
Right.
and it's a single member, you know, they thought it's okay, you're not violating any mortgage note, which.
Well, that's why I said as long as you don't add additional people to that
Yeah.
LLC. So Jane Smith
Yeah.
is the person who's on the mortgage and who bought the property, and Jane Smith is the only member of the LLC, you should be
Okay.
fine. I always warn clients too, saying, you have to be full disclosure with you. You can also call your lender and get consent. Now, 90% of the time they'll give it, because as long as they can see the only member of the LLC is the person who signed the mortgage, they're gonna be okay with it. Because at the end of the day, even if it's in the LLC, you're personally guaranteeing a mortgage and note. So they can still come after that person, no matter what.
Okay.
Their concern is if you do an LLC and it includes anyone other than the original buyer, then those other people have rights to the property and now the lender can't foreclose because they're gonna get sued by those other
Oh, I
people.
see, I see.
That's the lender's concern. So as long, most lenders will be okay with it after closing, as long as the only person in the LLC is the person who originally bought the property and is on the loan documents. Because then they can still come after that person and no one else can claim rights. They're concerned if there's an innocent third party who is now a part of the LLC, she gets foreclosed upon, they hire an attorney, it's like, well, this has nothing to do with my client. My client owns 50% of this property. You can take away the other 50%, but not my client's 50%. And that's when the lender will have a problem. Does that make sense?
So the lender is notified to like any quit claim it is the LLC.
The
right?
client has to call customer service and tell them that, hey, this is whatever my loan number. They'll ask you a bunch of questions. Say, look, I want to put this into an LLC because it's an investment property and I'm going to be the only sole member. They're going to ask you for some documentation to prove that. 90% of the time, they will say that's just fine because it's the same people. The LLC is just there to protect the individual, as you mentioned. And we're going to get to that next, if no one else has any other questions about owning it individually.
Okay.
All right, perfect.
Thank you.
No, no problem, please. That's what I'm here for. To ask any and all questions.
Interesting.
All right, so next is what we've already alluded to. The next way you can purchase real estate is in a corporate entity. So there's different ways you can do this, but there's two primary ways, and pretty much the only two primary ways people do this. I'm gonna just summarize and then we're gonna go to it in detail. The first is an LLC, which is a limited liability corporation, and the next is just a corporation, which is also known as Inc. So there's two different ways you can do this. An LLC is very similar to a corporation, where you're forming your own legal existence. People are called members. LLCs, and I'm going to get more into depth with this in a moment, they're easier to manage. So both entities provide a lot of protection. But a corporation, as we're going to talk about shortly, requires a lot more day-to-day management or year-to-year management than an LLC would. And an LLC gives you just the same amount of protection. It just isn't as painful to run an LLC as it would be a corporation. So let's talk about that. So let's say Joe and Jane buy a multi-unit together. They go ahead and purchase the property. They want protections in case a tenant ever sues them or something happens. So they want to set up a corporate entity. I would personally always recommend for individuals to do an LLC because the management of it is less. You're still protected. And basically it's a business now. So you start the LLC, 123 Main Street LLC. You open a bank account for that LLC. You treat it like its own little business. You file taxes for the LLC. What the LLC does for you is it protects Jane and Joe separately. If someone ever got sued, they could only come after the value of the LLC, which is typically the actual real estate, which is probably heavily leveraged by a lender, and then whatever is sitting in the LLC bank account. But they can't come after you personally. They can't take your home, your cars, unless you pierce through the LLC. Really quickly, what that means is you're not running the LLC properly. So you're like putting your own money in it without having documentation to prove it. You're taking money out of the LLC and just putting it in your pocket. You're paying yourself personally, whatever the case might be, you have to run it like a business. So the money comes into the LLC, then you pay yourself from the LLC. So you can't have an LLC and have the tenants write the checks to your name. They have to go to the LLC. So that's your protection. Everything stays in that little box. And that protects you if you ever got sued. Your liability is limited to whatever that LLC is worth, not what you are personally worth. Does that make sense? So overall, the reason why we want a corporate entity is protection. It also makes it easier for your accountants to file taxes and write things off because you are a proper corporation and you're running everything through that corporation. So they can write off more expenses for you because it is actually a legitimate business.
So in Schedule E,
Mhm.
you have 10 different properties, the same LLC name.
Mhm.
So in Schedule E, you put in individual properties and their income and expense?
You would file separate tax returns.
Oh, for.
Yes, it's a separate business, that's correct.
It's not gonna be scheduled.
No.
Oh.
Unless your accountant wants to do it another way to protect you for some other reason,
Yeah.
that's an accounting question. I would always talk to them. So the first thing is, let's back up a second since you brought that up, and I was gonna get to this in my notes as well, but before you set up a corporation, part of it's legal, part of it's accounting. So you always want to talk to an accountant to see what's best for you. 9 times out of 10, they're gonna agree with me and say an LLC, but if you're more sophisticated, if you have a lot of employees, they may say set up a corporation. So it just comes down to your personal, how your tax returns work, what your income is, what you're doing. But most of the time, the LLC will be sufficient for that purpose. But you always want to talk to an accountant first, just to make sure it's what's best for you. Because as an attorney, I'm not going to know your personal financial situation, and I can't opine upon that. My job is to protect you. Does that make sense? Okay, great. So,
Do
please.
you have 2 LLCs and 1 corporation?
You can have as many things as you would like. Sir. But now here's the thing. For investor clients, I always advise them to do a separate LLC for each property. Why? Because if you have multiple properties in one LLC and one property gets sued and you don't have enough to satisfy that judgment, they can come after any other asset in that LLC. So it's worth your money up front to do a separate LLC for each property. And then when you sell that property, just shut down the LLC. You're done. They can't come after anything else.
Can you also do like a master series?
So I don't recommend series LLCs because people tend to cross collateralize things too much and put themselves at risk. I think it's safer to just have a separate LLC for each property because that gives you the ultimate protection. Because let's say you have 40 properties and one gets sued, well, they can only touch that one property. They can't come after your other 39 assets. And that's what you want. You want to protect yourself.
No, in the LLC, it also has something called disregarded entity, which
Mhm.
means that they would not have separate tax return. And because that information will go into your personal tax return.
So that's up to an accountant. If that's what he's recommending for you, you could definitely do that. That does exist, but I don't want to give accounting advice, unfortunately. So I would talk to him about that. If that's best for your financial situation, you can do that, absolutely. Does that make sense? Okay, perfect. So next, we're going to talk about a corporation. Everyone sees things, IBMA, whatever it is. So you can also set up in a corporation. You can also put real estate into a corporation. But like I said, if you are just individuals, you're not a big business corporation, it just becomes more complicated to run the day-to-day or year-to-year of a corporation than an LLC. So I rarely advise a client to do a corporation unless they just happen to be way more sophisticated. They have employees, they have managers, there's all this stuff going on. Then I would recommend a corporation. If you have employees, the corporation is the better way to go. But now we're talking about a large landfill, that has office space, that has, 40 people, 400 people working for them. That's a different situation. For the most part, I presume the clients you're working with and yourselves, they're not them. They're just individuals who are buying investment properties or want to provide protection for their own property, whether they live in it or not.
So you mentioned that when you create your multi-unit into an LLC, and there is a $50,000 equity, that's all there is to go against.
Yes, whatever the value is of the property or whatever's in the LLC bank account.
Yeah.
So if you have 300,000 sitting in the bank account, they can come after that too. If you have $3 sitting in the bank account, they'll come after the $3.
So is it good to then constantly get that money out of there?
Yes and no. So if someone ever tries to say you pierce the corporate veil and they're trying to get through you personally through the LLC, you still have to make it look legitimate. Don't just keep $1 in there. You got to make it look like, so you got to show a pattern. Well, you got to show a pattern that the rents are coming in because they have to. You're paying your expenses to the LLC and then any profit you're paying yourself. As long as you're doing it correctly and not lying, it doesn't matter what's in the account as long as you have a paper trail to prove it. And then some people are taking losses. Some people can own an investment property and they're literally taking losses every month. So they're helping the LLC by making loans to it to keep it afloat. So that loan would get paid back first. We just have to have documentation in place.
So obviously want to do this for investment properties for protection. And but you said like on the first slide.
Yep.
You also always have property insurance too. So
Correct.
like, I guess in both cases. You're gonna have insurance on properties either way, if it's personally owned or corporate owned, but, I mean. Why is the personal one at so much more risk than the LLC? Is it because beyond the insurance policy, then they can still come after you for more, basically?
100%.
Oh,
But typically with your own single family home, the likelihood of you getting sued on something and insurance not covering it is gonna be very minimal. Because most of the time, what are you gonna get sued for your own house? A guest comes, slips and falls, hurts themselves, and they come after you. So that's why you have insurance in place. That's why you talk to your insurance brokers. That's why lenders require insurance on a property at all times. So the insurance brokers work with you to make sure you have sufficient insurance to cover that risk. Most people don't put their personal properties into a corporation. At the most, they would put it into a trust that Mary and I were talking about earlier, and we're gonna get to that slide next. So, yeah, Andy, to answer your question, it's just basically, you don't want them coming after everything you have.
Yeah,
When you
I
have
just
a bit
wasn't
in one
sure how
business.
much, yeah, like, what would go beyond.
Yes, yeah, and again, if you're very concerned, there's also something called an umbrella policy, which will protect you up to a certain limit above your current insurance. And if you do have significant assets, you should talk to your insurance agent about an umbrella policy. They are not expensive at all.
Right.
And they provide additional protection, like $1 million more, 2 million more, 3 million more. And at that point, you should have more than enough protection that you're not worried about your personal assets being upset. But umbrella policies are very important. Not all insurance agents talk about them, but they are not expensive. So talk to your insurance agent about that if you're concerned,
Especially if you're in business.
especially if you're in business.
What would be recommended if, like in Chicago, it's very common, we have the owner occupied two flat, right?
Yes.
So you live in one, you're renting out one, you
Sure.
have a little more risk now. Is it better to do the personal route or it's better to do the LLC route?
LLC,
LLC,
because you have a tenant in your property now. So it's still a business. You're collecting rent
okay.
and you want to protect yourself. And the tenant knows you live in the house, so they can come and knock on your door anytime. So I would definitely put it, anytime you're running a business,
Yeah,
renting properties, even if you live there, or you have a 12 unit, but you live in one of the units, it doesn't matter. It is better to put it into some sort of corporate. And we can always discuss what's best for you at that time, but 9 times out of 10, I would put it into that. And then there's minutia around that, which again, at any point that comes up, we can discuss that separately, but it's basically, think of it as a wall. So these are all your personal assets. This is your business. If your business is in an LLC, they can't get past the wall to your personal assets, and that's what you're trying to protect. Does that make sense? And as we know, in America, it's very litigious. Anyone can sue for any reason, and the courts will entertain it. So you don't want to have that stress if you ever did get sued. Any questions regarding corporate entities, the reason to do it? And again, we're not getting into extreme detail, but I'm happy to answer any questions anyone might have. Good? All right. All right. All right, so this is just corporate entities, just a summary of these, and I'm gonna send a copy of my whole PowerPoint to Nick, and he can email it to everyone, so everyone has this. So you don't have to take crazy notes. But again, like I said, it is much easier to operate an LLC day by day, year by year, than it is to operate a corporation. A corporation really shouldn't be done unless it's a real true business and you have multiple employees, and we can talk about that. Again, and as I mentioned, to your point earlier, any form of ownership, which is corporate, does require lender consent unless the property is owned for cash. But like I said, as long as the members of the LLC match the person who was on the loan, 90% of the time, the lender will not have a problem with it. As soon as you add someone else, they will deny it. They will say no, because then they have a problem. They can't foreclose on your property. They're going to have obstructions.
I tried it, the vendor would not buy this.
Even if it was just you, really? Like I said, you can still do it like that other attorney told you.
Yeah.
I have never had a client that,
Yeah.
unless you stop making payments. The
Correct.
minute you stop making mortgage payments, they're gonna look into everything.
Yeah.
As long as they're getting paid, as you know, lenders do not care. They just want their money.
Exactly.
They want their interest.
Then has this concern that you can add a member later on, right now we will allow you to do this, let us see. And you added another member down the street, your family member, whoever,
Right.
but now it's like the same. issue that we talked about.
Well, I have a way around that. So when you have an LLC, you have an operating agreement, which I said is like the Bible for the LLC, how it's gonna operate. You put language in, and this will satisfy lenders. I've done this for clients, and it basically says that there can be no change in ownership to the LLC.
Okay.
And if they see that line in there,
Yeah.
they'll be fine with it. Because they're gonna ask for your operating agreement to review it. So if it says you cannot add or subtract anyone, they will be.
Shane, do you do commercial loans, like for 5+ multifamily, or?
Yes.
And when they're like applying, do you have people applying as a corporation already, or usually is it?
Correct, those are, the majority of them are LLC. or-
It's different standard for commercial loans. Like I said, 99% of the people that's applying for a commercial loan are not doing it in their own name. I currently have a client that's buying a strip mall on Devon. It's got like 10 tenants in there and some parking. And I reached out to the lender just as a precaution, like, she's gonna buy this in an LLC, you know that? He goes, yeah, that's just fine.
And mostly it's done by smaller banks.
Yes,
Any the commercial lenders are not there anymore, you know.
Local banks.
So you
like
have
Gold
to-
Coast Bank, First Eagle Bank.
Yeah, and they ask you to open an account
Yeah.
there and keep their operating, you know. and
It's
they-
relationship banking. So they
Yeah.
trust you. They know you have the money. They know your assets are with the bank.
I mean.
And they know why you're getting an LLC. It's more sophisticated than a residential loan. Those loan officers understand why you're doing it that way. And it's really, it's more, it's formal, but it's also a handshake. They want to be in business with you so they can make money on your money. And they want you to do everything through their bank.
So unlike the residential loan, what we do is we actually help you find the right bank. And we have some relation with some banks, and they will just basically, but then you'll have to deal with them. My position would be just to facilitate them, so.
You're the broker. You're brokering the transaction. Yeah.
So, you know, so that's how it works, but, you know, it has to be small banks.
Yeah, an individual cannot get a commercial loan from Bank of America. You gotta be like IBM or something like
Yeah.
that. You're gonna go to a local bank that is gonna form the relationship with you and trust you. And the more business you do through them, whether you're flipping properties or buying them, and they see that every single time you're coming through, then they will start extending you more and more money because they want to make money on your money.
Exactly, and then they can give you a line of credit.
Yes.
they can- all kinds of-
And that's the eventual goal for most investor clients. They want to get that line of credit going so they can move fast on properties. Because let's say there's a bidding war, they can't get the loan done in time. Well, they have a line of credit. They can pay cash
Their
and
money's probably.
finance it.
Too.
They can go to the deed.
Yeah.
Okay.
And the more they like you, the more they trust you, the faster they're gonna get things done, because these small banks, the loan committee is a couple people and they can make a decision very fast. They don't have as much red tape like you're mentioning on a residential transaction. So that's kind of how that works. But again, if you are doing a business, whether it's big or small, you're buying 1 unit, you're buying 10 units, you're buying 100 units, you do not want to buy it in your own name, or at some point you want to take it out of your name. But once you get past a certain amount of units, as Andy was mentioning, it has to be a commercial loan anyway, and you're not going to have a problem purchasing it in a corporation. Most commercial lenders will not care. All right, any more questions on that before I go into the next piece of this? Nick, you're good?
Oh, absolutely.
Awesome. All right, guys. So next, Mary and I were talking about this at the beginning. So next is a trust, an estate, a will, whatever it might be. So if you have a trust set up for your assets, how things are going to happen if something were to happen to you, how succession is going to happen, protecting yourself from Uncle Sam when your estate goes to your children or whoever you're giving it to. If you have a trust set up and you are buying real estate, especially for yourself, your personal properties, possibly even business properties if you don't have partners, you want to purchase it in the trust. Because now your real estate is part of your estate plan from the beginning, and whatever the terms of your trust say, that's what will be followed if something is going to happen to you. So that's the whole reason you paid all this money to set up a trust, to set up a will. And if you own real estate, it should be in your trust, unless it's a business, then maybe yes, maybe an LLC is the better way to go. But if it's your personal property, your home, you live in Chicago, your vacation property in Florida, whatever it might be, you want that to be part of your estate, which is your trust. So that way, if something happens to you, whatever that trust says, that's what happens to your real estate for your beneficiaries. Plus, there's tax implications in that. There are laws, and when you guys have the estate planning seminar, there are laws in the US where a certain amount of your assets up to a certain number are completely exempt from paying capital gains. Because if something happened to you, you want your family members to get everything they can get. You don't want 40% of it going to Uncle Sam. So there's a lot of benefits, as I mentioned before, to having an estate plan in place and then having things put into your trust because it protects the next generation. No one wants to make all this money, save it up, have it for your kids, and then Uncle Sam says, I'm taking 40% before it goes to them. You want to
avoid probate?
so this is a misnomer, but everything has to go through probate, but if the right vehicles are in place, it is a very simple process because the documents will control marriage. So if like you have a trust, you said everything is going to your son, let's say, for example. It's going to go into probate, but there's no contesting that because it's in writing and that's what it says, and your wishes will be followed. Now, the converse of that is, let's say you didn't have anything in place. You passed away. You have $1 million in assets. It's going to go in probate. And that's what Andy was saying before. They're going to start going down the chain. They have to notify all your heirs that you have now passed away and see if any heir wants to come and say, I'm owed 20% of that estate. It's mine. And now you're going to be tied up in court forever because the judge will have to determine who are the true heirs and who gets a piece of your estate.
And was there something recently where there was kind of like a loner guy that in Chicago, I think that had like 10 million or 20, no one thought he lived like in a small bungalow, and
Yeah.
I think then like 30 people came to
Yeah.
claim it or something.
Yeah. So then once that happens, every single person that comes to claim it, that extends the amount of time it's going to be in court, and a judge has to figure out who gets this $10 million because the gentleman didn't think it through and didn't put something in place. What happens to my money? And if he has no heirs, goes to a charity, goes to whatever he wants. But if you don't trust him,
Well, they say if you hate your heirs, then do that.
Paul, you can give it to whoever. You don't like your children, you look at me like a guy, you can leave it to your pet. I mean, whatever you want to do, that's up to you. That's the benefit of, right, but it gives you control versus the court control.
Yeah.
You've worked your whole life to make all this money.
Yeah.
You want to be able to say who it goes to, not a judge. So that's the whole point in having that. So once an estate is in place, you can purchase property in a trust. And you may also know this as well, but when it's your personal residence you're buying, there's no scrutiny. They'll let you put it in the trust. It's not like an LLC where they're going to say no. You can put it in your trust.
And then it's like I'm executive trust, the trustee,
Mhm.
and then we have successor trustees. So if something should happen
To you, correct.
the next person takes over, so that
Correct.
wouldn't happen when other people still.
Yeah, absolutely, because there always has to be someone there to act as a trustee, and if you don't have anyone, they can appoint, there's companies out there that you pay, and they act as your trustee to act out your wishes.
So if we live in Chicago, Cook County,
Mhm.
is it Cook County that handles the probate process then?
Yeah, that's the kind of courts, yeah, that's the probate court.
And you can have a property in an LLC
Mhm.
and also have a trust.
You can put the LLC into your trust, yes.
Okay.
Yep, because anytime you have your estate set up, anything you do where it's value-based, you buy a property, you do something, even if you buy a car, whatever it might be, you need to make sure your estate attorney knows what's happening, because they might have to make small updates to your trust to accommodate that. Like, let's say you have 2 children, but now you have a third, and you never told your estate attorney you had a third child. Because you may not want to give any money to that child, you may want to give it all to that child now, but if he doesn't know, it's going to go based on what was originally written into your documents. So you have to make sure if big life changes happen, you let that person know. So Mary, if something changes, you decide, I want to leave all my money to Nick. Nick will take all your money, but
Yes,
you have to
I
let
will.
your trust attorney know that.
Yes, I
It's
will.
not going to Nick.
Yeah.
And not spend it wisely.
We have it set up, we can make those.
Yeah,
changes.
Nick's buying another boat with Mary's money. All right.
We put the IRA in there, the insurance policy,
Everything.
the bank account.
Everything.
So a trust is like an umbrella then?
A trust is part of your estate plan. So it's like you can have a will, but it's part of your part of your estate plan where it's kind of segregated off, but it dictates what happens if you were to pass away. And you can have anything in there you want. So it could say, I have $30 million, I have 3 children. They don't get any of that money until they turn 21, because anything below that, you think they're going to frivolously spend it. You can put whatever terms you want. As Mary probably knows going through this process, you can tell them what you want to happen to your estate.
So if you have like 10 personal homes, I'm not
Yeah.
talking like the corporate home, but you have all these vacation properties or whatever.
Yeah.
Are they all under one trust?
Yeah, they go into your
Oh,
trust.
okay.
Yep, because that trust, the trust document is what dictates what happens to it if something were to happen.
So then you would contact your attorney, like every time you get another property.
Just let them know.
something like that.
Just let them know, because they'll also have broad statements in there in case you forget to. It'll say, whatever my assets are when I die, 1/3 if it goes here, 1/3 if it goes here, 1/3 if it goes here. So whether you've told them or not, it encompasses all of your assets. But if you want something to be very specific, like my home in Malibu, California goes to Joe Smith, you have to let them know. So they can carve that out and know that that property is going to somebody else.
So if you dictate this before the closing date on the title, is it going to say trust 1, 2, 3, 4? Or
That's a land trust. It'll be bought in whatever the name of the trust is. So like Andy's trust dated January 1st, 2024, whatever the trust name is, the attorney comes up with the name of the trust with you. That's, yeah, it is what it is. So title will go into the trust name. Typically trust, personal trust have the person's name in it, but a land trust, really quick off topic. A land trust is held by Chicago Title, and really the only benefit of doing a land trust is if you want anonymity. You don't want anyone to know where you live or where your house is. This got Nick very excited.
That's, I will say, when I did with my place, and let me tell you, a time or two, that was very helpful.
My home is also,
Like the cheapest, lowest
yeah,
option.
there's an annual fee, there's an initial fee, and that's it.
Myself in
Yeah.
the Chicago Land Trust. No one can cold call her, no one
Yeah.
can solicit her, because
Yeah.
you don't know who the owner.
They still, there's ways they can
There's
still
ways.
find out,
Yeah.
because let's say you subscribe for J. Cruz magazine, now everyone has the information of where J.
Yeah.
Cruz magazine is going
But I'm
to.
just saying, she's done.
Yeah, it's a
She's like
protection.
to be anonymous.
But if someone goes to the recorder of deeds and says, who lives at 123 Main Street, it's gonna say Chicago Land Trust number, or
Right.
whatever it is, it's not gonna have your name. So if you are worried about someone knowing where you live, you would purchase the property in a land trust, because then there's complete anonymity.
Now, you
unless-
still get the tax write-off. as
It's
limited.
your home. All it is the land trust owns your home,
Okay, got it.
and they sign a side agreement with you saying you're 100% beneficiary to that home. But that side agreement is not public record, so no one else knows it other than you and your estate attorney, because they need to know what you own,
Sure.
even if it's in a land
That's
trust.
a nice way to do it. No one knows what you own.
And if you don't have a will or trust and you have it in a land trust, as part of the land trust, you can elect beneficiaries for your land trust, or you can have more than one person who is a beneficiary to the land trust.
It's kind of funny that more celebrities and stuff don't do that. I mean, I'm sure there's leaks where people like.
Most of them do LLCs, but there's so many layers to their LLCs that no one can find out who they actually are, or they have their people like named on there. So like, let's say Goldman Sachs manages their assets. You'll see on the LLC, it's actually Goldman Sachs, but you're not gonna know who the actual end person is. So they do protect themselves, maybe not in land trust, but they have very sophisticated means and ways that they set up super complicated entities. So no one can ever find out who the actual person is.
Mark Anthony was being.
So if you have a trust and you listed all your properties in
Mhm.
it, but you have one piece of property that's in your personal name,
Mhm.
is that a problem at the time of death?
No, because your trust will still say, here's what happens to all of my assets, and that's still one of your assets. So even if it's in your own name, it's still part of your estate. It's just, it's gonna follow what it says. So if it says 1/3 and 1/3 and 1/3, that's what it's gonna do. But let's say you wanted that separate property only to go to Nick, and you didn't spell it out in your trust, he's not gonna get it. Does that make sense? It goes what your overall trust is.
You might still go to probate, correct the title.
They don't need to correct the title, because it's part of your estate. You still own it, even though it's not in the trust name. It's still part of your estate. Because your estate will stay, and when you go through the process, it'll be more self-evident, but you'll make these decisions. You'll say, here's where I want my assets to go by percentages or just a specific asset. So even if the asset isn't in the trust, like for example, let's say you have an expensive watch. You didn't buy the watch in the trust name, it's just yours. That is part of your estate. So whoever that is going to as part of your estate or being sold off, it goes to those beneficiaries. It doesn't have to be in the trust name necessarily. What I'm saying about real estate though, is if you're buying it and you're gonna live there or it's a vacation home, since you have the trust, you might as well buy it in the trust name.
Title.
So later on, there's no headaches. Does that make sense?
Yeah.
Okay, that's the real reason. But all of your assets get distributed according to what you want. When you sit down and figure that out. And like Mary said earlier, you can always make changes.
We actually had to go through probate on a piece of property that was in a personal name,
Okay,
but it was in the trust.
okay.
And
Why did they make you go through probate on that? Was there someone contesting
I
it?
had to make sure, well, two of the owners
Mhm.
that were deceased.
Oh, there was more than one
and
owner.
One
That's
was still alive.
That's why. That's why. If there's multiple owners and each owner has their own trust or estate plan, remember, part of the property's theirs, so now it's getting divided. So yeah, then it would definitely have to go
Two of
in
the
front of the
owners
judge.
didn't put it in trust.
All right, so then it would go into probate. That's absolutely correct. This is just, if it's only you, it's your estate, it's your trust,
And then you pay the.
your
lawyer.
wishes will be followed.
15 or 20 grand and you're done.
Right. Any other questions on that? All right, perfect. As we cruise on down, so now we've kind of gone through everything, the different ways you can own real estate. I know we've been doing question and answers as we've been going through this, but I'm happy to open the table to anything anyone would like to talk about,
So.
outside of what you're having for dinner tonight.
So when you are a realtor
Yes,
and you get to the point where you want to start doing let's say flips,
Mhm.
where you will own the property, let's say for 100 days.
okay.
And then sell.
Mhm.
When you purchase that property,
Mhm.
it should be ideally in an LLC.
Well, it depends now. So now we're going back to, if you're taking a residential loan to purchase that property, it's very likely the lender won't let you purchase it in an LLC. You would have to wait till the deed gets recorded, which can take 60 to 90 days, and then quit claim it into an LLC. But if you're only holding the property for 100 days total, I wouldn't do that. Just make sure you have enough insurance in place to protect yourself. Because it wouldn't make sense to do it. If you're flipping it that fast, you're not gonna have the time to do all that. There'll be chain of title issues. Does that make sense? So if you're doing quick flips, unless the lender, for some reason, like you're working with a small community bank, you have a relationship with them, they have a lot of your money in their accounts, they would likely allow it because you're running a business.
You'll probably also likely be doing hard money though.
That's true. For quick flips, you're not getting normal loans.
Yeah, and when you spoke about homestead.
Yeah.
Does homestead apply
No.
for those, let's say, 100 to 120 days?
Homestead rights only apply to your principal residence where you live. If your spouse is not entitled on the property that you live in,
After 12 months.
and you were to sell it, and you were to sell it, then they would have to sign off waiving it. But for your business properties, for your flips, there's no homestead because none of you are living there. You're not living in the property. It's a business. So at that point, if you start doing enough of them and you have a good relationship with a community bank, I would just set up one LLC and just keep buying all the properties in that LLC because you're not holding them for a long period of time. You're getting out, you're getting your money, you're going on to the next. Does that make sense? What you're saying is a little bit more complex. We can talk about it offline, but there's ways to structure that to protect yourself. But your time period is too short to take just a regular loan for a flip, which you're not going to get, like Andy said. It's going to be a hard money loan at a much higher interest rate because they're expecting you to get out of this in a few months. They're not going to give you a 30-year mortgage for a flip. They're just not going to do it. Does that make sense? Yeah. So yeah, that's a whole different scenario.
Question for you,
Yeah, please.
LLCs, like if you do an LLC, can you do like a series?
We talked about
You
this.
just talked about that, okay.
You absolutely can, Nick, but here's my thing. I've seen too many people set up a series LLC and unbeknownst to them, they do something which they're not understanding what they're doing, and all of a sudden they cross collateralize all their assets. So I always suggest people buy real estate in separate single purpose LLCs because then you're completely protected and it's much easier to manage.
Perfect, okay, that's what I wanted to clarify,
But yes, there are series LLCs.
but don't do them, that's.
You can if you're sophisticated enough, but
We're not.
that's a different,
We're not, attorneys are not.
that's a different discussion that's a different
I
discussion.
I just was wondering, is that such a default answer, and I've heard now that it's kind of going on both.
It is, and
Yeah.
actually there is a bill up, I don't know if it's come up yet, but they're looking to get rid of the series LLC in Illinois. I don't know if it's gonna pass or not, but they're trying to get rid of it.
Can you explain what series means?
So series LLC, as Nick just alluded to, would mean you have like one LLC, so 1, 2, 3 Main Street, and underneath that, you have a bunch of sub LLCs. As many as you want.
As many addresses, let's say the sub.
Well, whatever you name your
let's
sub
say the
LLC,
sub LLCs are the.
address of the property, correct.
Different addresses.
Correct. So they all tie up together. You have to manage them separately, but you have to be very careful that you don't do something wrong with one of the LLCs. Otherwise, everything in the chain is at risk. So I don't recommend a
People do
serious
that,
LLC.
like, I think I've seen way too many Instagram videos, but where they're like doing like, you know, tax avoidance or something, is that sometimes the reason for some?
I mean, maybe that's more a question for an accountant. I don't know that for a fact. Maybe there's ways to do that. I'm not sure how they would pull that off because real estate's still a trackable thing and they know when you're buying and selling it.
So also with I know there's also things I've heard that, you know, people do what the Delaware LLC
Yeah.
or the Wyoming, I don't know.
Not necessary.
I mean, if you're doing a residential, investment property in Illinois,
Yeah,
does it matter which state?
it doesn't, but I would keep it in Illinois. Because it makes it easier for you, because remember, if your LLC is in Idaho and you get sued, they can make the venue Idaho. Now you're flying to Idaho all the time, hiring an Idaho attorney to defend you, and you're making your life very miserable. I would say it doesn't really matter. I would keep it in the state where the property is. Or if you have investment properties, like let's say in Florida, but you live in Illinois, I would still do an Illinois LLC because you could try to get the venue to be Illinois for the lawsuit.
Which we hope does.
Right, but you never want to get to the lawsuit. That's the avoidance of having the corporate structure in place, is to avoid that. Or if it does happen, the judge throws it out really quickly. Or if you are actually liable, you're limited to what's in your LLC and they're not coming after your personal effects.
And one of my clients, the LLC, the former LLC was $450, used to like maybe a few years ago.
Yeah, the state always changes it.
So now they're cut down to like 150.
I think it's $250 if you're doing it online, yeah. And then you pay an annual fee.
Correct, and then, so if you have 10 properties, one of the things was the CDs, was cheaper because you make one and the rest of them.
They're cheaper. That's correct. It's to save a little bit of money.
$50.
Correct.
So that's probably why.
Yeah, well, no, but now they've dropped the price of creating an LLC. At one point it used to be like 600 something, now it's like
Correct.
250 or whatever.
Sure.
So when they've dropped the price, so it just makes more
It
sense.
makes sense, yeah. It makes sense.
I don't know why Illinois wants to drop this series. I just think it's very complex and a lot of people don't understand it and they set it up and they don't truly understand what they're doing.
So basically, when it comes down to you're buying maybe that owner occupied two-flat, you need the residential to be in your name, the mortgage to be in your name, right? You wait then until title is recorded, and then you can, quit claim it to the LLC.
Correct. Correct. Unless you're doing a commercial loan or some sort of small bank that's not selling it to Fannie or Freddie, and they're gonna let you do it because you have assets with them or a relationship with them. It's not completely unavoidable, it just depends who you're getting your loan from.
Do you also have to wait till the mortgage is sold on, if it ends up going to a different?
To transfer the name? No. No, mortgage is still in your name, you're still liable, they're gonna find you gotta pay.
Oh, no, I just, sometimes they sell it off, right?
Yeah, no, that doesn't matter. You cannot transfer a property out of your name until it's in your name. So if it takes the county 60 to 90 days to record a deed, it's not gonna show your name until the deed is recorded. So you can't transfer it out of your name until they know it's in your name. Even though you legally own the property at the time of closing, public record doesn't change for a while. Make sense? Okay. Any other questions from anyone?
Check to see if there's any questions in the chat.
Yeah, please. We didn't check that.
Real quick. Your friendly moderator over here. Oh, just checking in. So just for the future, guys, we are gonna at Cottage Grove session, which is on. I'm gonna give you the date of this real quick. So guys, write this down. The day after Valentine's Day, we're gonna send a little love to the earth with a 11 a.m. to 1 p.m. session at 7300 South Cottage Grove. Is gonna be hosted by Wayne Beals, another amazing specialist in our community. He's an agent right here at Exit, has owned his own brokerage, has done amazing stuff with the green and sustainable space. So that is on the 15th from 11 to 1 p.m. But my only point of bringing that up today, in addition to just having you reserve the date, is we are going to have a little bit of a microphone set up there. So if you guys have questions from the back, the people that are in the audience, because we love these hybrid meetings, are going to be able to hear you a little better. So at home, if you guys had a little struggle with hearing us today, we will not only have the slides for you as a Google Drive link, if you're okay with that, and your contact information. That will be in the YouTube link that I will send out to everybody that registered through the Eventbrite. So awesome. We good for questions? Would you guys like?
Our customers too.
Would you guys
Yes.
like to do a raffle real quick? So we have an amazing, I heard this was a good vintage. This is the Namit, wine. I'm kind of jealous. We need to get some exit strategy wine. Yes, well, it's on my list of swag that we, but, so this is gonna go home with one of you guys, but we have a pop quiz in order for you to do that. What year was Exit Strategy Realty founded? First one to answer correctly wins the bottle.
1985.
I'm not that old.
2009.
2014.
2009, Andy, October 2009, sir. And you've been with us since when? September 2000, or when we met in 11. So we're getting some miles on these relationship guys. Thank you again at home.
I know you like vodka, so I don't.
I like it all. Guys, thank you so much for being here today. We have pizza for those of you guys in class. This is amazing.
And thank you to Nick for allowing me to be here and hosting this. I appreciate
This
it.
is my pleasure, guys. All right, we will see you later. And we will also have at the end of March, the last week of March, it will be either the 26th or 27th. Tuesday or Wednesday, that will be when we have our estate planning meeting. That will be for consumers, realtors, and it will be a hybrid meeting in our Joliet office and also on Zoom, same as today. Thank you, guys.
Thank you.
Bill was on with us.